Hi, I'm Steve Looney. I'm chair of Dean Mead's Tax and Corporate Department. And we just finished giving a presentation on the new Florida Revised LLC Act, and I thought I would go ahead and talk about a few of the highlights that we went over in the seminar. First of all, I think it's really important to realize that the new act is not just an amendment of the old act, but it is a complete replacement. Florida Chapter 605 now replaces Florida Chapter 608 as the new act applicable to LLCs. As far as the effective date goes, any LLC that was formed in 2014 is subject to the new act, but more importantly, all LLCs beginning on January 1, 2015 will be subject to the new Florida Revised LLC Act, and the existing act will be repealed as of January 1, 2008. There are a number of changes, and again, I'm just going to try to hit the highlights of those changes. First thing to take into account is the new act has over 69 definitions compared to 17 in the current act. One of the things to point out right at the outset is that the new Florida LLC Act has over 69 definitions. Under the current act, there are only 26 definitions. So just the fact of all these new definitions really will necessitate one to review their current operating agreement to see that the definitions that are being used are in compliance with the new act. Also, there's been a big change in the number of non-waivable provisions that you cannot alter by reason of the operating agreement that the statutory provision controls. In those situations, which are 17 now versus the 6 under the prior act, again, you cannot alter those particular provisions. They're non-waivable and cannot be changed. So you need to examine your existing operating agreements to see if you have any of these non-waivable provisions included in your pre-existing operating agreement. The new LLC Act also deals with the authority of members and managers of both member-managed LLCs and manager-managed LLCs. As far as statutory apparent authority, if you have a member-managed LLC, all members are treated as having statutory apparent authority. With respect to manager-managed LLCs, only the managers have statutory apparent authority and the members do not. Another important concept that was changed, I talked about the addition of a lot of definitions. Also, one big definition and concept was eliminated in the new LLC Act, and that is the elimination of the definition of a managing member of a member-managed LLC. This is going to create a thorough examination you're going to need to do of your operating agreement where you have a pre-existing member-managed LLC that appoints a managing member. Since that no longer is a defined term, you really have one or two alternatives. Either convert to a manager-managed LLC and make your managing member the manager, or there's a new concept under Florida law, which I think is extremely important, and that is LLCs can file statements of authority to designate who has the power to contract on behalf of the LLC and to expressly limit who does not have the power to contract on behalf of the LLC. And I think that is going to be something that many third parties, such as banks, title companies, probably any third party dealing with an LLC, is going to require as a matter of course in the future. Another one of the changes made by the new Florida LLC Act deals with the duty of loyalty. The duty of loyalty is multifaceted, but one of those duties is not to compete with the business and affairs of an LLC of which you are a member. Now, under the new LLC Act, the duty of loyalty only applies to managers of a manager-managed LLC and not to the members of a manager-managed LLC. With respect to member-managed LLCs, the new LLC Act provides that all members are subject to the duty of loyalty, which would include this duty not to compete. And that differs from existing law, which only imposed that duty of loyalty on the managing member. So this difference in duty of loyalty is very important, and I think one thing that probably the drafters did not think about was Since the duty of loyalty did not previously apply to non-managing members of a member-managed LLC, as of January 1, 2015, there's going to be this springing duty of loyalty that now all of a sudden applies to these members, and that is something that needs to be addressed in the operating agreement. Another important aspect of the changes made by the new LLC Act, they have added provisions similar to the corporate provisions that allow, in addition to mergers and conversions of LLCs, they also add interest exchanges and domestication of foreign LLCs. Probably the last really significant change made by the new Florida LLC Act relates to the rights of a member to dissent from a corporate action, such as a conversion of an LLC or a merger of the LLC. First of all, the Act makes two primary changes. First of all, it provides that appraisal rights, or the right to dissent to these corporate transactions, is applicable to a much broader class of transactions. Specifically now, a member can exercise his so-called appraisal rights to be paid the fair value of his interest when there is a sale of substantially all of the assets of the LLC, which did not exist under the current LLC Act. Secondly, with respect to the appraisal rights a member has with respect to one of these events, in determining what is the fair value of the member's interest, the new Act expressly provides that you do not apply marketability and minority discounts in determining that fair value. Again, that differs from the existing Act, which says you can apply those discounts with respect to LLCs having more than 10 members. And it's also important to note that minority and marketability discounts still apply to dissenting members of a corporation versus an LLC, where the corporation has 10 or more shareholders. So this may come into play in when you're making a choice of entity decision as to whether to use a corporation or an LLC.